Court of Appeals of Tennessee is in session.
Good afternoon and welcome to the afternoon session of the Court of Appeals. Your panel this afternoon will include Judge Armstrong from Memphis, Judge McGee from Savannah, and I'm Judge Golden from Memphis. Each side, as you know, will have 15 minutes. The appellant can reserve 5 minutes, up to 5 minutes of their 15 minutes for rebuttal. If you haven't already done so, you can request that rebuttal time. You may please call the next case.
Jeremy C. Koffman versus Madison County, Tennessee et al.
We'll hear from the appellant.
Thank you. Good afternoon. May it please the court. My name is Jason Yasinski. I represent the plaintiff appellant, Jeremy Koffman. At this time, I'd ask to request 3 minutes for rebuttal.
All right, sir. You may
Thank
proceed.
you. Your Honors, the case before the court today involves a violent attack on Jeremy Koffman while he was housed at the Madison County Jail. The defendant, appellee Madison County, they moved for summary judgment in the court below, which the court granted. And we're asking that the court reverse the judgment of the court below for basically 2 reasons. First is the attack on Mr. Koffman was foreseeable based on the facts in possession of the Madison County Jail prior to the attack. Second, that the Madison County Jail is not immune from suit in this case, as it failed to follow its own mandatory policies and procedures, and thus failed to use reasonable care to prevent the attack on Mr. Koffman. On January 9th, 2018, Mr. Koffman was booked into the Madison County Jail. He was placed in Unit 106 of the jail's C pod. Shortly after he was placed in that unit, he laid down on the floor to go to sleep. He was then, as viewable on the jail's security camera footage, awakened by another inmate who ordered him to move from where he was laying and relocate to the front of the unit, which was outside of the view of security cameras. Feeling as though he had no choice, Mr. Koffman moved his mat to the front of the unit and laid down again. Shortly thereafter, inmate by the name of Cedarius Reeves approached Mr. Koffman and threatened him that he should not touch his own food tray or Mr. Reeves would beat him up. Mr. Koffman told Mr. Reeves that the food tray was his. Another inmate, Aquarius Clark, joined inmate Reeves in threatening Mr. Koffman and was soon joined by inmates Timothy Perry and Jerry Crossland, all of whom physically attacked Mr. Koffman.
Let me admit, Mr. Jasinski, are you pursuing this against any of the inmates? Well, with regard to any of the activities of the inmates other than Reeves? In other words, is there any potential foreseeability with regard to the other inmates that were involved in the attack, other than perhaps Reeves, based on, I assume, on your argument that there was prior information regarding him?
Your Honor, we believe that Mr. Reeves was the instigator. He's the first individual who approached and began to threaten Mr. Koffman, and the foreseeability is certainly with respect to this instigator, Mr. Reeves, based on the notes that were in his jail booking record of the identical situation asked. While there were other inmates that were involved in this attack, it's clear that Mr. Reeves was the instigator in this.
All right.
And when Mr. Reeves instigated this attack, 4 inmates total began a brutal physical beating of Mr. Koffman that endured for over 7 minutes. During that attack.
Let me ask you something. You said from the information in the record, the jail should have known that this was foreseeable. The information in the record had to do with taking food trays. Was there anything else in the record that indicated that he was likely to commit an aggravated assault on another inmate?
Yes, Your Honor. I believe that the important information in that record is not just the food tray entry. It's bullies inmates for their food tray. That references a personal interaction, a threatening interaction that in a jail setting is certainly something that would lend itself to foreseeability for this very type of attack. In fact, it's because he had previously bullied inmates for their trays. That was a foreseeable action that was placed in the record for the very reason of warning other jail employees, officers, that this very act will happen again. And that's what happened. Mr. Koffman was threatened for his food tray. And when he declined to abide by Mr. Reeves' threats, that's when the beating began. This beating, again, happened for over 7 minutes, and officers did not report to the cell until 31 minutes after this brutal attack began. This was a foreseeable event that should have been prevented. Again, this notation in the record was there as a warning. And this is one of those rare occasions, again, where we get to use common sense. Why is a warning given? And that's to prevent future harm. The future harm in this case is that someone be threatened and then attacked in the exact manner that was listed in the inmate record. Tennessee law is clear in the context of inmate-on-inmate assaults. If a jail knew or had reason to know or had reason to anticipate an attack, the assault is foreseeable. And this knowledge is knowledge of specific threats to a group of inmates or an inmate's prior institutional history of violence, or any other specific information that would provide prison officials with actual or constructive notice of foreseeable harm to a group of persons. So again, it's not that there has been a cookie cutter past event of aggravated assault, but are there specific items that would provide these officials with actual or constructive notice of foreseeable harm? The analysis here should be very simple. Based on inmate Reeves' past history in this very jail of threatening other inmates for their food trays, this record was clear that this had happened in the past and was likely to occur again in the future. That's the reason that it's placed in the record. This, in fact, did happen again, and Madison County failed to take any steps to protect and provide a safe environment for Mr. Koffman. And this takes us to the next part. In the trial court, the order on summary judgment basically extends blanket immunity to Madison County for anything related to their policies and procedures. But there are clear policies and procedures that go directly to the safety of inmates. And these are mandatory policies. Again, I believe everyone agrees here that creation and promulgation of jails policies and procedures, those are not at issue. But the failure to follow these mandatory procedures and policies is, and that removes immunity from the county. Captain Tom Rudder, who was the Rule 30.026 designee for Madison County, testified that these were mandates upon the employees. For example, watch tours were to occur every 45 minutes to visually monitor and inspect the units in person. Now, Mr. Koffman has disputed that this occurred during the time that he was in Unit 106, but the officers have stated that they performed these watch tours. The jail requires, though, that these watch tours are documented with times and results. In the deposition of Captain Rudder, again, who was the designee for Madison County, he was asked to produce these logs to document these watch tours. No such logs were produced. This leaves the inference that those logs don't exist. Construing that inference in the light most favorable to the appellant creates a very strong inference that the watch tours did not, in fact, occur every 45 minutes. But there's an additional mandate for more frequent in-person observation when certain conditions exist. Madison County's General Order 10.4.001 states, and I'm quoting, "Observation is performed more frequently in areas where inmates are known to be combative, potentially suicidal, mentally ill, or have demonstrated bizarre behavior which could create a danger to inmates or staff." The booking records for the inmates housed in Unit 106 show that there were combative inmates, notably Mr. Reeves, with his documented bullying, inmates with bizarre behavior, again, that would apply to Mr. Reeves, as well as inmates who had suicide precautions and known gang members with violent histories. So the conditions were present and known to the officers, which would require in-person observations on a more frequent basis than just the every 45-minute tours, which again, there's a dispute as to whether those even took place. In addition, there is a mandatory policy for Madison County Jail that two-way voice communication capabilities exist at all times. This mandate was also disobeyed by the Madison County Jail, Only the officers in the control tower could communicate with the inmates via voice communication. Inmates cannot communicate back with the tower. When asked if the policy for two-way communication was being complied with at the time, the county's designee only stated, quote, "I don't have knowledge of it if it was or not." He then went on to confirm that the intercom system is controlled by the staff. So at a minimum, there's a question of fact as to whether this policy was being followed. But the reality is the inmates clearly have no meaningful way to communicate with the control tower in case of an emergency. The only way that officers even noticed that something needed their attention following this particular attack was an inmate waving a towel for the camera so that officers could hopefully see him on the camera. Having officers in control of an intercom, but having no way for the inmates to communicate other than by waving a towel can hardly be seen as two-way voice communication. Now, most importantly, Madison County Jail is equipped with surveillance cameras in each CPOD unit. The cameras did not provide full views of each unit, however. So each unit had blind spots which couldn't be seen by the officers in the control tower. Now, again, Madison County's argued the placement of the cameras is a discretionary function, which was approved and ratified by the Tennessee Corrections Institute. While the placement of the cameras might have been a discretionary function, the requirement to provide still should have used reasonable care to ensure that the areas that were not visible were as safe as those that were able to be seen. In this case, when the surveillance of
Freezing.
exercise of reasonable care, that an emergency situation existed and should have immediately gone to the cell. Instead, the officers who we submit were not performing proper in-person watch tours. They waited for their attention to finally be drawn by an inmate who was waving a towel. The officers who were in the control tower stated, I believe in their affidavits, that 30 seconds after being notified by that waving towel, they were in the cell. Well, at the point that the blind spot became at issue, when inmates started to congregate in the blind spot, it would have only taken them 30 seconds from that point to go and stop this 7-minute long beating and attack on Mr. Koffman. This is something that could have been done and should have been done. This was a foreseeable attack, and it was preventable based on following their own mandatory policies and procedures. At a minimum, there are questions of fact as to whether the policies of Madison County Jail were followed. Again, this was not addressed. Instead, there was just a blanket of immunity given to Madison County in the court below. And for all those reasons, we would ask.
You'll have your rebuttal time, Mr. Yasinski.
Thank you, Your Honor.
Thank you. All right, we'll hear from the appellee.
May it please the court, Nathan Tilley on behalf of the appellees. Your Honors, it is our position that the circuit court correctly granted summary judgment in this case because based upon a plethora of case precedent, this assault was not foreseeable and we cannot be held strictly liable just because an assault occurred at the jail.
Mr. Tilley, let's discuss this issue about the knowledge that the county had. That notation on the booking report with regard to Mr. Reeves talks about not only taking other inmates' trays, but bullies them also. Do you equate bullying with propensities to a violent activity?
I do not, Your Honor, and I don't think that in a jail setting, any reasonable officer would equate the word bullies other inmates with someone who has a violent propensity. I think that
how would you describe it? How would you describe that activity?
Well, frankly, Your Honor, the term bullies is not necessarily, it's a pretty vague term. I don't think that a note in a booking record that someone bullies other inmates is sufficient to put anyone on notice, especially in a jail setting where we're dealing with people who are dangerous. In a jail setting, a word that someone bullies is certainly not enough to put any jail official on notice that that person is likely to assault someone. I think another important point, Your Honors, concerning your question, is that the proof in the case is not that inmate Reeves was the first inmate to hit Mr. Koffman. It was a different inmate. It was inmate Perry who hit Mr. Koffman first. In fact, according to Mr. Koffman's declaration, he himself acknowledged that inmate Perry punched him multiple times before Reeves or any of the other inmates did. And there is certainly no proof in this record that inmate Perry, no note that he was a bully or anything that would put anyone on notice that he would assault inmate Koffman.
Did this start with a tray incident? Did it start with that?
According to inmate Koffman, yes, Your Honor. According to inmate Koffman, one of the inmates requested his tray in the cell.
Was it Reeves or do we know?
I believe he said it was Reeves, but I think again, there's nothing in the record to show that Reeves ever assaulted an inmate over a tray. That's not in the record. And I think if you look at the case law on this, it's going to support our position. One of the cases that comes to mind for me is Cook v. State that we cited in our brief. In that case, the assaulting inmate had a history of having a knife in his possession. He had a history of stealing sheet metal while performing his inmate jobs. And the court said those facts weren't enough, because to be foreseeable in a jail setting, there has to be something that would put the jail officials on notice that the victim is going to be attacked. And in this case, Mr. Koffman, he admitted he didn't know he was going to be attacked. So he never told anyone he was going to be attacked. He didn't have any idea that an inmate was going to attack him. And because of that, he never warned anyone that he was going to be attacked.
Well, why would this notation, on the booking report, why would they even put something like this down if it didn't concern them? In other words, if there wasn't some concern about this kind of activity going on, or that it had a propensity to, to create issues like this.
Your Honor, your question about why they put it down, that's not the answer to that question is not in the record. The question of why they put it down or why they would have put it down, that's not in the record. I will tell you that in a jail setting, things are noted all the time about inmates. And Mr. Reeves, who had been housed, I believe, at the penal farm, was being moved to the jail. It's possible they just noted that. Things about inmates are noted all the time. And just because, and maybe
does that not some indication of a propensity of foreseeable type behavior?
It could be an indication that he bullies inmates, but it's not an indication that he assaults inmates, because there's nothing in there that says he assaults inmates. And I think that any further reading into that goes beyond what's in the record. And what's in the record is solely what's in that note. And there's nothing at all that would indicate to any jail official, but just based on that note, that Mr. Koffman was going to be assaulted. Another case that comes to mind, Your Honor, that we cited is Gillespie versus Metropolitan Government. In that case, the plaintiff inmate actually verbally requested from officials to be moved. And the reason he requested to be moved was because he said, quote, "I'm worried there's going to be trouble." Well, I could say, well, trouble, that sounds like someone's going to get assaulted. But that's a vague term. That's a vague term. And the court said that's not enough. That's not specific enough. For there to be foreseeability, there has to be a reason that the jail officials would know that an assault is going to happen. And a simple note, in one of the 4 or 5 inmates who were involved in this assault, and again, not the one who started the assault. He's not the one who started hitting first. That's not enough to put Madison County jail officials on notice that the assault is going to occur.
Is it the county's position that this has to be foreseeable as to this specific person? Is that your position?
I think it is, Your Honor. Yes, it is. I think that, you know, a scenario I could think of where it would be a little bit more general than that would be if we knew that an inmate was a member of a rival gang of another inmate and they were housed together. Okay, there could be some issue there about, well, we know they're in rival gangs. We know those gangs don't get along. Maybe we shouldn't house them together. But that's not the case here. And you know, I will point out that Mr. Koffman was asked during booking that day, is there anyone you know of that's incompatible? No, there's not. Is there any reason that you believe you're going to be threatened here? No, there's not. He goes into a cell, he goes to sleep, he wakes up and he's assaulted. There's nothing to indicate that the jail official should have done something differently to prevent that assault from occurring. And I think that the case law strongly supports our position on that. Case after case after case says if the victim never warned officials that he was going to be assaulted, if the officials had no reason to know he was going to be assaulted, you can't hold the jail liable. Jails are dangerous places. Assaults happen in jails. They hold dangerous people. You have to have some specific facts to show, hey, we need to do something to prevent a potential assault. That wasn't here, and I think the circuit court correctly recognized that, Your Honor.
Let me ask you, Mr. Tilley, concerning 4 inmates involved, was there, and I don't know how long they were in the jail, is there anything in the record about whether they had ever assaulted another inmate in the past while in the jail?
No, there's not, Your Honor. Of all the inmates involved in this assault, there is nothing in the record to show that any of them were ever involved in any other assault. The jail had no notice that there's nothing in the record to show that they had any idea that any of these inmates would assault an inmate or had ever assaulted an inmate. Your Honors, I think the key case is the Supreme Court case King versus Anderson County. I think that's a helpful case to consider. You know, one of the things that appellant brings up is trying to create issues with watch tours, camera blind spots, housing minimum custody inmates in the cell. Those are all issues that don't touch foreseeability. And I think I've addressed those. I don't think there's merit to, I think the undisputed fact is we were doing watch tours. I think the undisputed facts are TCI approved where our cameras were. It's a discretionary decision where to place cameras. I think it's undisputed that Mr. Koffman was housed appropriately. But besides all those points, none of those issues touch on foreseeability. And I think King versus Anderson is a good case to consider that point.
What about this language from King versus Anderson, where it says, for purposes of assessing a penal institution's liability or an inmate's prior institutional history of violent behavior or any other specific information or conditions that would provide prison officials with actual or constructive notice of foreseeable harm? Is that's out of King?
It is, Your Honor. I think it supports my position. There's nothing in the record that would have showed that any of these inmates involved in the assault with Mr. Koffman were going to participate in an assault of Mr. Koffman or of any inmate. And I think that the question about, we cited a case in our brief, I believe it's KGR versus Union City School District. And in that is a school board case, but I think it's pertinent to the question about whether the word bully creates a foreseeability that there's an assault that's going to happen. In that case, the minor plaintiff had been sexually assaulted by another minor in school. And the proof showed that prior to that sexual assault, his mother had written a letter to the school that said, my son is getting bullied at school by these students. The court held that general statement is not enough to make it foreseeable that he was going to be assaulted. Now, that was in a school setting, the court held that. In a prison setting, it's even more true that the word bullies is insufficient. We're dealing with criminals. The word bully is nothing unique for criminals. And I think that's where the heart of King is. A jail is a dangerous place. It holds dangerous people. A jail is not an insurer of inmate safety. And because of that, those things, an assault can happen without any notice or any fault on the jail. That's what happened here in Koffman. And it has to be something more specific. If Mr. Koffman had walked into the jail and said, you know, I've had some problems with inmate Reeves in the past. I'm afraid that he may beat me up. Well, that's some notice. We didn't have that here. And it's just like in King, same set of facts. Now, going back to what I was also saying about in King, one of the biggest arguments that plaintiff made, one of the main arguments he made, was that he had been housed too long in the jail. And because he was housed too long in the jail, an assault occurred. And the Supreme Court acknowledged, yes, you probably were housed in jail too long. But just because they housed you too long doesn't make the assault foreseeable. And I think that's applicable here when appellant tries to create issues concerning watch tours. Well, whether watch tours happened or not, it didn't make the assault foreseeable.
But also in King, there was no record of any institutional behavior problems. So there was basically a clean slate in King. None of the inmates involved in that had any that the institution had any indication that there were any institutional behavior problems. That's not quite what you have here.
We have a generalized statement that he bullies other inmates, that one of the four, the one who didn't start the fight, who bullies other inmates for their trays. That's what we have. That, in our opinion, Your Honor, respectfully, is not enough to place defendants are on notice that he is going to assault someone. Those are two very different statements. Bullying other inmates it did not make it foreseeable that Mr. Koffman was going to be assaulted on that day.
Was there an opportunity to depose these inmates to see who was involved or what occurred or any of that? Was any of that in the record?
There are no depositions taken in this case, Your Honor. There was plenty of time, but no depositions were taken. Other than correct myself, other than a 30B6 of Captain Rudder was taken.
All right. Thank you.
Thank you. I think I concluded my argument. We would ask that the court affirm the circuit court's decision.
Thank you. All right, Mr. Yasinski, you have 3 minutes on rebuttal.
Thank you, Your Honors. First, I wanted to address this, the argument that the duty somehow shifts to Mr. Koffman to protect his own safety and to provide notice to the jail, as opposed to the jail's duty to provide a safe place for Mr. Koffman to be housed. To say that Mr. Koffman should, at the time he was booked into the jail, advise that Mr. Reeves and he were incompatible, a fact that he could not have known, to advise that Mr. Reeves had previously bullied individuals for food the way this would now happen to him, he has no way to know that up front. Instead, it's the jail that has this knowledge and already had this knowledge at the time. And with respect to the term bullying, I think we're all citing the same language from the King case, that jails are dangerous places. If you look at the totality of circumstances, bullying inmates for their food trays does not present itself as a fun-loving act. This is something that would cause, it raises alarms with respect to inmate safety. And to the extent that counsel suggests that bullying is a vague term, then the inference is in our favor as to the way this should be construed. And at a minimum, there's a question of fact then. But the inference is that this is a dangerous condition that was created. The school board case is also distinguishable. And again, I'll turn back to King. The school board case deals with I believe it was middle school, and a general allegation of bullying then leading to sexual assault. We are talking about a jail that is distinguishable from a middle school. Jails are dangerous places, but not just in the general manner of saying that jails are dangerous places. We have a specific notation of past bullying for food trays, threatening someone for food trays, and that is the exact conduct that happened in this case. In our reply brief, I believe we successfully factually distinguished all of the case law that has been cited, that there was no, and in many cases, there was no notice of any behavioral disturbances on the assailant's part in these jails, that in some cases, the victim and the assailant had gotten along in the past, were actually friendly. This is not what we had in this case.
Is there in the record with regard to Mr. Reeves, did he in fact participate in the violence?
Yes, I believe that's Mr. Koffman said that all 4 inmates physically assaulted him. That is in Mr. Koffman's declaration.
All right. Okay. All right. Thank you. Any
Thank
questions?
you.
Any other questions? All right. Thank you very much. We appreciate the argument in this case. It's a very interesting case. We'll take it under advisement and give you our opinion as soon as possible. Thank you.